Hey everyone, welcome back. Today we're diving into a fiery Senate hearing where Senator Josh Hawley argued Congress should let citizens sue big tech. This is about challenging the power of Google, Meta, and Amazon. Let's get into it. Hawley thanks expert witnesses for their antitrust work. Antitrust laws are meant to protect consumers and small businesses, but enforcement is lagging, especially against tech giants.
Chairman, thanks for holding this hearing. Thanks to all of the witnesses for being here. Ms. Harper, if I could just start with you, I want to thank you for the great work that you do on antitrust enforcement. We've worked a lot, your organization, my office, so thank you for everything that you do. And something that you are very focused on is revitalizing antitrust enforcement, because revitalizing antitrust enforcement is really about protecting our markets, promoting competition, and getting a good result for consumers and workers. Is that fair to say?
Very fair, and other businesses as well.
And other businesses as well. Yeah, well said. Let's just talk, though, about some of the barriers to antitrust enforcement, effective enforcement. This is something in just my short time in the Senate that I've seen over and over and over again, is that antitrust suits that you would think should be brought don't get brought by the government. Suits that you think should be pursued don't get pursued. So can you speak to some of the barriers to effective antitrust enforcement that you see out there that you're familiar with?
Well, I do think big tech is an area where we've been quite impressed with just the wide range of suits that have been brought by enforcers and bipartisan enforcers across multiple administrations at this point. And that's encouraging and something that we've already discussed a bit today at the hearing. But usually what is most challenging for enforcers is having enough resources. These guys are often outgunned by the big tech firms that have unlimited budgets. The former chief legal officer at Google said publicly that they had about $1 billion to manage any sort of legal risk that was presented to them as a company. And we have enforcers that even in these trials will have about 1/10 of the resources that any individual defendant that they're taking on might have. So put all of that on turbo speed when it comes to big tech, and the inequity in resources is quite stark.
Yeah, that's startling. $1 billion, and that's versus government enforcers.
Hawley digs into a little-known section of the Clayton Antitrust Act, Section 15A, which lets private citizens sue companies for anti-competitive conduct. The law is clear. Anyone harmed in business or property can file a suit, but most don't, because it's expensive, risky, and intimidating.
Who have the resources of the government. I noticed that in the Clayton Act, anybody who's familiar with our antitrust statutes knows this, the Clayton Act, 15 U.S.C. Section 15A, the statute says that any person, I emphasize any person, who shall be injured in his business or property by reason of anything forbidden in the antitrust laws may sue, therefore, in any district court of the United States. That's a private right of enforcement. So the Clayton Act allows private suits, and yet it's usually, there are private antitrust suits out there, but usually it's government suits that we see. Is that because of the resource imbalance, do you think?
Yeah, it can be difficult to find a plaintiff's attorney that's willing to take on the risk. And again, when we're looking at bringing a suit against big tech, you are taking on not just the biggest giants of the United States, the biggest giants of the world that have unlimited resource. That can be quite intimidating for anyone who's running their own law firm.
Absolutely.
If you found this helpful, hit subscribe for more deep dives. Hawley's proposal is clear. Congress must revamp private antitrust enforcement. That means changing outdated court restrictions and allowing class action suits so small businesses can unite. Even bounties could reward those who take the risk to sue.
Here's what I'm getting at. I just wonder if it's time that we took a little bit different approach to antitrust enforcement. I wonder if it's time that Congress, in addition to pursuing some of the other goals and goods that we've been talking about today, I wonder if it's time we revisited the power of private suits in antitrust enforcement and began to make those viable again. Courts have closed down access by private parties to antitrust enforcement suits by imposing injury and standing requirements that I think, frankly, are somewhat suspect. We could fix that. We could allow class action suits in the antitrust context. We could open up the courtroom doors and allow private parties access in such a way that it would make economic sense to bring a suit, and you'd have a better chance of prevailing. I just wonder if it's time we start thinking outside the box a little bit, or maybe it's not outside the box, maybe it's getting back to first principles, because this is, after all, how the Clayton Act was written. It was written to allow not just government enforcers, and we understand the importance of that, but it was also meant to allow injured private parties to get into court and have a real shot at enforcing the law and recovering damages, treble damages under current law. maybe we ought to increase those damages awards. Maybe we ought to change some of the injury and standing requirements that the courts have imposed that I think, frankly, are not there in the text, the history of the Clayton Act.
Real legal threats, not just fines, would force big tech to change. Nothing makes a CEO sweat like the words jury trial. A government fine? They can budget for it. But a private lawsuit from a competitor, risking billions in damages? That's a whole different story.
There's something that is, I think, particularly market reinforcing about private suits, because you have private actors who in real time are responding to harms. If they are properly incentivized and able to get into court to enforce their rights, that's good for the company. That's good for all of the other people who are in a similar position. It's good for the government. The government is not expending resources. It's good for the market. As it turns out, the people who drafted the Clayton antitrust law were pretty smart, actually. They had a good intuition 100 years ago, and maybe it's time that we made better on that promise.
That's what the Clayton Act envisioned. And honestly, it's time to fulfill that vision. As the hearing ends, there's agreement. We need more tools to stop big tech from abusing its power. The government needs more funding, but citizens and businesses must also be empowered to fight back. Congress must act with real reforms, restoring a courtroom open to everyone. This wasn't just a Senate hearing, it was a wake-up call. Big tech won't regulate itself, and government can't do it alone. If Congress opens the courtroom doors, we can all be part of the solution. Hit subscribe for more political breakdowns and tech accountability. Thanks for watching. Stay informed.